We are back on Morning Line. Thanks for joining us on this Monday. Nick Barris, along with News Channel 5 legal analyst Nick Leonardo. We're going to take this up to 9 o'clock, and then we're going to go over to the Birch Building, where there is a hearing before Judge Monty Watkins on the Vanderbilt rape trial. We're going to take you inside the courtroom. We'll have it here, as well as streaming video. And it's going to be interesting. We were talking to Nick in the last segment. We can take some of your calls if you want to jump in about what some of these motions are all about. Severing. We already talked about how there is going to be a jury coming from outside this area, from Chattanooga. And then I was asking Nick during the break, and maybe you're wondering this, what are the chances of it actually happening on November 30th? That the judge you would have thought originally when he set the date could have thought, well, let's just start fresh right in the new year after the holidays. But no, he's wedging this right between Thanksgiving and Christmas, almost as though he's thinking, you know what? I just want to get this done and out of the way before the new year for everyone involved, including the alleged victim.
Well, you know, now that these two individuals are on bond, they're not as much of a priority as someone who's been in jail. So if you're in jail on a multiple offense DUI, let's say you weren't able to get out and make bond, your case would come first prior to someone on bond for the charges that Mr. Vandenberg and Beatty are on bond for.
But why not just push it to the new year? You know, I'm just saying, because there's problematic things. Bringing a jury in right after Thanksgiving, before Christmas, and everything like that. Why would he have chosen November 30th? That, I take from that there's a sense of urgency here, that after this first debacle, you know, we want to just get this over with. And we want to do it right, but we want to get it over with.
Well, see, you know, the court's been setting I mean, when the court has been setting trials, you know, for the last year that are happening this week, okay?
Right.
And so, you know, when the court was setting trials, they had no idea that there was going to be this juror misconduct and that this case was going to be overturned. So what the judge has to do is to try to find a three-week slot in his schedule where there's no other trial set. And this may be one of the only opportunities that he has, because if you remember, this did go 3 weeks. Now, if this was a 2-day trial, you know, it probably would, you know, you could fit it in a whole lot of different places, okay? But that's part of what the judge has to look at is, you know, where can I fit this in so that I don't prejudice other folks that are in jail and other trials that I've had set, because this thing kind of came out of nowhere again.
Okay, all right. Well, and with the viewers, and I know I've had some calls and emails when I talk about this on Facebook, and if you want to jump in on this, they're wondering why on earth, because we talk about a possibility of a plea deal, why on earth would the prosecution offer the defense any type of plea deal when we know the evidence they have, and the most damning evidence is the videos, and not just the video that was taken on the cell phone of the attack, but the video of their conduct in the hallways and walking into the dormitory, and all this showing the cavalier attitude toward this unconscious female, and all this that's just, I think any jury sees that's going to be angered by it, and it's very damaging. So I think the prosecution holds all the cards.
Well, there's no doubt the prosecution holds all the cards in this particular case, and I think that if the even in the severance issue, like I said, if the state chooses not to use certain statements, then, you know, I don't think it's eligible for a severance. But if they decide and they're firm that they want to use them and the judge does sever them, then I think that's something else the state's going to keep in mind in the back of their head. You know, we're at least going to have 2 trials here with 2 sequestered juries, and juries rather, and it gets very, very expensive, and, you know, the District Attorney General's office has to apportion their resources. And at the end of the day, we have what's called the Victims' Rights Amendment, and that means that the victim has to be apprised of everything that goes on in the case. And, you know, it's nice to have her agree to any disposition or any offer. Now, with that said, the victims don't control the DA's office, but that DA's office does a great job of really talking to the victims and making sure that they're aware every step of the way what's going on. And I believe this victim actually has her own lawyer, which is something we hadn't seen before, in Ed Yarborough. And so, you know, I think that she may want to go forward. I think it's clear that she's willing to go forward.
That's right.
But, you know, if these guys are willing to take some offer that put them in jail for 6 or 7 years, means the victim going to be okay with that? Is, you know, the state going to be okay with that? You know, that's what you have to look at. I think at the beginning, these guys didn't think that there was any chance they were going to be convicted, and so they didn't even entertain the possibility of jail time. And so now I think they're definitely on the page after being in there for 6 months. They've had a taste of it, and I think they realize, you know, 20 years versus 5 or 6, that's a big gamble.
Yeah, and it's important to note here the lead prosecutor remains Tom Thurman, but you said, and I think it's worth noting, that the current DA inherited this. Glenn Funk was not the district attorney when this happened. That was Torrey Johnson. And so now he's in charge, and obviously he wants to see justice done. But is there a different dynamic there?
You know, I mean, you take the good with the bad, I guess, when you run for public office and inherit something like that. And this is a big case, and you know, this was something that General Johnson did, you know, bring the indictments on, and now General Funk's handling this now. You know, I think it's the first. He wasn't involved. I think he took office after the verdict.
Guess so. Right. I'm trying to remember. It was right around that time.
Yeah,
exactly.
right around that time. That's right. Yeah, actually, it's exactly right. So you know, again, this is something that he inherited, and it's still up to him. I mean, he holds all the cards, and you know, the DA is one of the most powerful men in every jurisdiction. I mean, if a crime is committed and the DA chooses not to prosecute, and there's not a federal offense, and that's where it ends. And so he has, you know, a lot of power, and he holds all the cards here.
Now, he himself is not prosecuting the case. It's Tom Thurman and his team of lawyers, the same team probably coming back. But so would they be running, or they're going to be in talks with General Funk if they're discussing any possible offer? Or is it possible that the defense could come to them and say, hey, listen, we might be willing to listen at something like this? It can go both ways?
It can go both ways. I don't think the state's going to be beating down anybody's door to try to make an offer. I think they would listen to anything that the defense team, you know, brings to Tom Thurman. But I can assure you that in a case of this magnitude, any offer that's made, I mean, General Funk's going to be apprised of. No doubt.
Okay, but it's a high-profile case. I think a lot of people remember watching this first trial, which got a lot of coverage, and a lot of people followed it here on the Plus, and they saw these two guys convicted. Okay. And they saw them looking at what? What kind of time were they looking? We never got to the sentencing stage, recall. They were waiting for sentencing when this whole hullabaloo came up about the jurors. So they were never sentenced, but we knew based on their offenses, they were looking at minimum 20 years?
Well, they would start at the, you start at the midpoint, so that's exactly right. You know, minimum of about 20 years. And these are 100% crimes, which means that they're not eligible for parole on the aggravated rape or the aggravated sexual battery. So any time they receive would have to be served at 85%. And so typically most of the sentences that you see in the criminal justice system have a parole eligibility date. Doesn't mean you're guaranteed to get out, but after you serve 35% of your sentence, you go before the parole board and they determine, you know, if you were good while you were there, if you're a first-time offender, then they'll put you on parole. But these kinds of offenses, you're not eligible for parole. So they're very, very serious. And the question that, you know, I guess in the defense team's mind is, was Judge Watkins going to run them consecutive? You know, there's numerous counts, and each count of, you know,
could have really stretched it out, right?
Stretched it out. He could have been looking at 40 years, 60 years, or he could have run them all together. Okay,
yeah.
And so that's really the million-dollar question. I'm sure that some of these defense team folks have is, you know, what is Judge Watkins likely to do? I mean, if the judge is likely to stack these convictions, I think there's no doubt that these guys are willing to sign up for a whole lot more jail time. You know, I think 10 years is better than 40, because 40 years would, you know, there's a chance that these individuals may not live to get out of the penitentiary.
All right, again, the number 737-7587. Not a ton of calls coming in just yet, because I wonder if some people, you know how it is, you move past a trial and you forget some of the details that came with it and what went into it. Now, a lot of people are aware there's going to be another trial. But I wonder, as I think back on the defense and what they tried to present the first time around, and clearly the new lawyers, and Warwick Robinson is still the attorney for Corey Beatty, but as they look at what they did last time, and they're coming back for another bite at the apple, if it goes to trial, do you, Nick, and you're an attorney who's dealt on both sides, does the strategy change at all? I'm trying to remember the first time around in Vandenberg's case, they tried to make the case that he was not responsible. He may have been in the room or in the hallway, but there was no evidence that he actually touched her in that video. I think it was determined that he's the one that used his cell phone video to video what was happening to her. As for Corey Beatty, it was almost at the end there, it appeared as though Warwick had him throw himself at the mercy of the jury by actually taking the stand in his own defense. Does any of that change this time around, knowing that it didn't work the first time? What can they do differently?
Well, I mean, I think that both the state and the defense team have gone back and reviewed this in their mind. You know, even before there was a mistrial, you know, you go home at nights as a lawyer.
Yeah, you want to know, what could I have done differently?
Right. You know, maybe I should have done this, maybe I shouldn't. But one thing's for sure, both sides have had a bite at the apple. They've had a dry run. They see how their evidence plays out. And I think big things are, you know, something that stands out in my mind is, if I'm Warwick Robinson, I've seen what Corey Beatty does in front of a jury. I've seen whether or not, you know, you can have him in your office, you can ask him these questions, you can rehearse his testimony. But you know, again, on game time, game day like that, and you're sitting there in front of 12 people, it's a whole different ball of wax. And so I think that, you know, you will make some adjustments based upon that. You know, and of course, this interview with Dr. Phil is going to be something that if Corey Beatty takes the stand and testifies to something maybe a little bit differently than what he had stated in the Dr. Phil show, I think that, you know, that's going to come in potentially for impeachment.
Well, you know, the Dr. Phil show, and we all watched that interview after it came around. I mean, I didn't see much new ground covered, and I didn't see him really contradict what he said when he took the stand the first time around. I don't know how that'll play out. I mean, did you think there was a lot of... Well, I'm trying to remember specifics, but I didn't watch Dr. Phil and go, wow, that's something I didn't hear in the first time. I didn't see much new ground covered there. That was like, wow, that could come back. Nah, I didn't see that.
One thing I did see, and I don't want to misquote, but you know, I think that the general, the gist of what I remember from one of these comments was that, you know, Mr. Beatty said that he and Mr. Vandenberg would continue to be friends or something of that nature, or continue to have contact, and I think that, you know, that may turn a potential juror off. Okay,
and also one of the defenses, remember, too, when he finally took the stand was blaming it on this culture of drinking and promiscuity, and that Corey had so much to drink last night he couldn't remember. I thought prosecution did a good job of talking about, hey, he was lucid enough to order that meal from a Mexican restaurant and everything else. But I mean, that didn't seem to wash with the jury, right? The whole drinking and trying to say, well, he can't really be held responsible for it because he was so drunk, he had so much to drink.
Well, you know, you're not allowed to make what's known as a jury nullification argument. You know, like you're not allowed to get up there and say, well, it's just, you know, it's just wrong, and or, you know, it's just this cultural thing. And so they did a good job, because I think there's something to that argument about this culture. Okay, and I'm not sure exactly what details may have emerged, and they're not really allowed to get into those kinds of details. But you know, I don't know that necessarily played well with the jury. Obviously, I guess it did not. But there's something else that, you know, we haven't seen anything about, and that is, I think the state tried numerous or several times to kind of suggest that maybe there was something put in this alleged victim's drink. Remember that? All those kinds of
the Long Island iced tea, or some kind of blue liquid that she drank at the bar that night.
And you know, I would have thought that maybe we would have seen some motions to kind of tone that theory down. And I don't know that the state will go back that direction and kind of suggest. And I'm not trying to say they were trying to suggest that, but as an observer, I don't know about you, but I got the impression that there were some overtures that maybe there was something in this girl's drink.
Right, and there had been testing done and things, but keep in mind, she did not come forward or was not in a position to be tested or to have a rape kit or anything like that done till, was it 2 or 3 days later when she was approached. Remember the details of this, if still you're joining us and you haven't followed it, was this incident allegedly occurred in this dorm. Something did occur, and she had no recollection of it. And Vandenberg and others were around her the next day, and she was still, and it was law enforcement that became aware of what happened based on some security video, they said, and they approached her. And initially, remember, she was talking about how, no, he would never have done that, I can't believe it. And then they showed her the video, and that rocked her world, is my take on it. And that's how it came about. You're dealing, again, that's what we thought going into this trial the first time around. How problematic would it be having an alleged victim in this case who doesn't remember anything about the attack?
That's right.
But she turned out to be a very, very strong witness. We can talk more about that, and as well as a little bit more about the jury selection. It's going to Chattanooga. But remember, there was a lot of national play on this, and I think it was 2020 that somehow got hold of a treasure trove full of the video that was shown from the dorms. You remember seeing that? My jaw dropped. I'm still not sure why. You know, the court comes down on me sometimes when I get little tidbits here and there. Man, I had nothing compared to what 2020 had, and I have yet to hear any judge get upset or DA about the fact, like, who released that to them? You know, there was a ton of video released.
Well, you know, and you're exactly right. But if you remember, I believe that a couple of the police officers were interviewed. It seems like it must have been the day or two after the conviction when those interviews were done, because it looks like they were done at the Criminal Justice Center with the 2 detectives, and these individuals had already been convicted. So, you know, again, we don't know how that information got leaked, where it came from.
Yeah, we don't know. But I can tell you this. A lot of people thought Fletcher Long wasn't him. Because if it was, he probably would have given it to me. But he didn't give anything to me. So I don't know where it came from. But, you know, that video is now out there, and there are jurors or potential jurors possibly in Chattanooga that have seen that because it was a national news program. I don't know how big a role that plays in the selection process. Talk about the questionnaire, too, to avoid the debacle. We'll take a break. If you want to jump in, 737-7587. If you have any questions or comments, or you just sit back and listen to us discuss the case, 9 o'clock we'll take you over to the courthouse where hopefully we find out for sure today, one way or the other, whether these cases are severed and whether we're still on course for a November 30th trial, which to me still leaves me shaking my head. I'll believe it when I see it, but it looks like we're on track. We'll be back right after this.
This is a story.